And now it's time for Judge Joe Brown. He's the real deal in the courtroom today.
He took my car, hit a deer, and now he doesn't want to pay to fix the damages.
It was an accident. The deer jumped out. There's nothing I could do about it.
A deer meets a cougar, and the result is not pretty. Student Baina Sherman is suing her sister's boyfriend for damages to her Mercury Cougar. Defendant Rick Huger says it was an accident and he should not be held responsible. Now, here's Judge Joe Brown.
Am I correct in my impression that the plaintiff, Madam Plaintiff, that the defendant is your sister's boyfriend?
Yes, sir.
Okay. What sort of vehicle was this, please, ma'am?
Oh, it's actually a 99 Mercury Cougar.
All right, it rolls.
Yeah, it's a good car.
So you happen to have left it at your mother's house?
Yes, I did.
How long had it been there before you returned to discover that it had come afoul of mischief?
Actually, it was only about a couple of days. It was about 3 days.
Oh, you went out of town. You went to a funeral, right?
Yes, I was attending a funeral in New Jersey. And I came back home, and I asked my mom, I was like, where's my keys? Because I needed to go to the store. And she was like, oh, I need to tell you something. Your car was an accident. And I was like, well, what happened? Are you okay? She was like, no, it wasn't me. Ricky was driving your car, and he hit a deer.
What's Ricky doing driving my car?
That was my first question. So I said to her, I was like, Mom, what was Ricky doing driving my car? And she said, oh, he called me and asked me if he can use the car to take Shania, which is my niece, or pick her up from school. So, which I don't have a problem. I love my niece to death, but in the same token, that's not my responsibility.
That's his girlfriend's child.
Yes, sir. And he didn't ask me. And I'm pretty sure if he doesn't have my number, he can get it.
Now, did you get an estimate done on your vehicle?
Yes, I did.
Let me see it, please.
Sure. It's all my evidence together.
Let's go to the defendant. That's a basic case. What do you have to say?
All right.
I am very curious.
All right. So when I had dropped her off during that, when the bus came, I'm pulling off. I'm going back home, returning the car to her mom, and a deer ran in front of the car and banged right into the light. So I'm trying to avoid it and swerved into the ditch, and that was it from that point.
Well, was Bambi all right?
I got out to see if he was, but I didn't see him. So the only thing I can say is that she is right. But at the time, when she was asking for the payment, economically, I was having problems financially, so I couldn't do it. So, when I explained...
Then what are you driving for?
What's that?
Why are you driving if you can't handle the financial consequences?
Well, I was just trying to be responsible.
That's not responsible. It's called financial responsibility.
And
now, why are you in that situation?
Because of the deer.
What do you mean because of the deer?
The deer ran in front of the car.
43 years old, and you don't drive too well, do you?
I drive.
Now, see, one thing that I'm intrigued by,
yeah.
You should be very familiar with the financial responsibility laws because you just passed the written test for your first driver's license last year. So here you are, 42 years old, before you get your first driver's license.
Well, you got some people that have a license for 20 years and still can't drive.
But I'm
so that
very
doesn't justify how you drive.
That not in New York City, not in downtown Manhattan, not in Brooklyn, but in Durham, North Carolina, you're 42 before you get your first driver's license in life. That says volumes. Come on up here. You her sister. Why didn't you put some words of wisdom in your boyfriend's head? What's the problem?
Honestly, I feel like the whole situation is like a misunderstanding.
Well,
because
yes,
of the fact that
you
that
haven't
is my
paid
sister.
and she's aggrieved.
But we tried to go through, certain avenues with her
like
as
what?
well. Like we were the ones who actually got the initial estimate for the car.
Well, then why didn't you deal with it?
Because at the time I thought that both my boyfriend and my sister had insurance, but I don't understand.
She may have had insurance, but by the way,
Yeah.
that ups your insurance rates if you turn in a claim where that person is involved in an accident.
And I understand that completely, Your Honor, but
So why didn't you take care of your sister?
because we tried to take care of my
Yo,
sister.
you didn't. Why didn't your boyfriend submit it to his insurance
We got
company?
angry at each other. It turned
Yeah.
into
Well,
an
why
argument.
did we get angry? You took a
Argument.
car without permission.
Well, prior to that, like we used to have her car a lot. You know,
Why
it wasn't a
didn't you
problem.
help?
Because we tried to help, and then she started getting belligerent
And
with us.
by
and
the way, the
leaving.
plaintiff has a different understanding of why you didn't help.
I don't know I can't understand what that understanding may be because.
Well, he didn't have money to handle it. You're unemployed, so what's the income? You two are playing house with each other and can't afford it. Don't have your own car, so you go get sisters. Now, what's your understanding of what the problem was?
Well, Yana, I know for a fact that the problem basically came from an incident me and my sister had which had totally nothing to do with the incident that me and Ricky had. When we were in New Jersey, she loaned me a pair of earrings. The process of us coming home from New Jersey, I lost one of the earrings. So I told my sister it was my responsibility. I'll buy her a new pair of earrings.
No,
she
she
said, oh no, Ricky has insurance, so on the earrings, so we're gonna wait and, get the insurance, and then I'll tell you how much the deductible is from the insurance from the earrings. So this was about 2 days. 2 days go by, I don't hear anything from neither one of them. I call her about the second day, maybe 3 days. So I said, Kataya, what's going on? What's going on with the earring situation? Did you find out if he has insurance or not? Oh, well, I didn't ask him. He's at work, but when he gets home, I'll ask him. Knowing that both of them had cell phones, she could have easily called him on his cell phone and just said, hey, baby, whatever the case may be. But she's, so I was like, well, what's going on with my car? Did he mention anything about, the insurance or anything? Oh, no, well, did you find my earring? I was like,
That's
what?
not true.
That's
not
true.
true.
Excuse me, Your Honor. I was speaking.
That's not true.
Don't be rude.
Well, since both of you seem to have financial wherewithal and insurance, I'm just wondering why after you jacked Bambi jumped out and attacked the front of her vehicle in your custody and under your control, you didn't take care of her. What's the problem?
Initially, we were going to take care of her. The only time that the earrings actually came into play was the fact that once she started calling us, being very ignorant, belligerent about the fact. So I used my earring as an example to say, well, with us in the car, it was an accident. We didn't intend on hitting
But the point is who
Bambi
gave
or
you
anything
permission?
like that.
Who gave
But
you?
I also gave her, permission to wear my earrings, and she lost one of my earrings, and I was just trying to give her the comparison to say, okay, if I'm treating you fair about something that was
When's
an
the
accident,
last time
why
you've
we
heard
couldn't
of
get the same
stop
thing
talking,
in
stop
return.
talking, stop talking. When's the last time you heard of death by earring assault?
Thank you.
I never heard of death by earring assault.
Yes, well, two-ton automobiles have a lot of kinetic energy. They're very good and efficient devices to reduce the excess population.
We'll be right back with Judge Joe Brown.
But can I say something, Your Honor?
What?
I don't think you should. You letting everybody know. That's me.
Yes, that's what happens when you have these things.
And later today,
She then called me one day and asked me if she could borrow my mattresses because her air mattress had got a hole in it and broke. So I said, well, I'll ask my dad since he's the one that purchased them.
She never said that she had to ask her dad for permission because they were hers.
It's Joe time after this.
we're back with Judge Joe Brown. The plaintiff in this case was surprised to hear her sister's boyfriend had taken off in her car without permission. Imagine her shock when she found out he crashed into a deer. Let's take a look.
The plaintiff is at a funeral in New Jersey with you, and she does not know that her motor vehicle is going to be used to be driven by someone with the first driver's license in his life less than a year before his 43rd birthday. Bambi almost gets jacked. And what if it had been a person jumped out there and she could have been stuck with responsibility for the injury, the liability? So see, that makes it a totally different situation. Therefore, you win, you prevail.
So, Joe,
Judge.
Can I say something?
Son, it's Esquire, Your Honor, Judge. I don't know you that well. I've got you in the level of, you know, I'm a lot more grown than you are.
I apologize for that.
No, you're way out of line.
But can I say something, Your Honor?
What?
I don't think you should. You letting everybody know. That's me.
Yes, that's what happens when you have these things. The fact that you are 43 years old and have had a driver's license for 1 year of your life depicts to me a profile about what your attitude is and your capacities to operate a motor vehicle. Grow up, you're not a child anymore. You can't be protected from the consequences of your miscarried activities. So pay up. You owe $413 for the tires that you blew out going into the ditch, $412.58, and you owe $1,039.49 for the vehicle, $1,452.07, and you'll get your court costs. That's your reward.
And this courtroom is now in recess.
Looks like a case of arrested development. The defendant waited a long time to get a license. Then he drove a car without permission, wrecked it, and couldn't pay. He's going to have to. Now, we're on to the next case.
Please raise your right hand.
Salesman Dennis Green is suing his daughter's former friend for the value of 2 mattresses. Defendant Ashley Soroy says the plaintiff's daughter gave her the mattresses.
All right, sir. This is your daughter's friend, right?
That's right.
That's your daughter. You
Correct.
come on up. You're the mother of the... Come on up.
No, ma'am. Right next to your
Next
father.
to your father.
Right here.
Okay. How did this come about? You first, sir.
Well, it's sometime in November. She asked my daughter to borrow the mattresses.
You asked your friend to borrow the mattress?
No.
Okay.
Okay? And I told her at the time I didn't think it was a good idea. But she talked me into it. And so she gave her to Ashley, and Ashley came over and picked up the mattresses. She was supposed to borrow them for a couple of weeks until she could replace her mattress. And that was back in November.
All right. What do you recall that you did, please, young lady?
Well, I met Ashley early in August. In November, she asked me if she could borrow my mattresses because her...
How did it come about that she would have the assumption that you had mattresses that might be subject to being borrowed?
Oh, because she was over at my house, and I had, we were out in the garage, and she saw the mattresses laying there next to my bed.
Now, when you say
my
my house, my bed, my garage, are you referring to your father's residence?
I'm referring to my parents' house,
All
but
right.
I lived there at the time. And she then called me one day and asked me in November, probably around Thanksgiving, if she could borrow my mattresses because her air mattress had got a hole in it and broke. So I said, well, I'll ask my dad since he's the one that purchased them. And so I went to my dad and asked him, and he said, well, I don't think it's a good idea, but then, like he said, I talked him into it, and I said, Ashley promised she would give him back as soon as she got new mattresses for herself.
All right, now, sir, why were you storing the mattresses to begin with? Surplus to the household requirements?
Well, my daughter moved back in with her mother, my wife and I, and she was living with us at home, and she had the mattresses previous to that and a bed, and we had all that stuff stored in the garage. We had an antique bedroom set in the bedroom where she was staying, and so she was sleeping on that.
All right, and you mentioned in your complaint that you did not want to particularly turn this antique bed over.
Right, it was a bedroom
defendant.
set that was my mother's, and I didn't want her to have it, basically, The mattresses that we were going to give her were stored in the garage.
All right.
So those are the ones that she
So
borrowed.
she slept on the antique bed mattresses, meaning your
but
daughter.
then she was going to move into an apartment.
And you would give her her old 3-year-old mattress to take with her.
That's correct.
Gotcha. Now, okay, let's go to you.
Okay. It happened about 8 months ago. It was not in November. That we used to hang out every single day, night. She was over one night and in my room with my mom and my stepdad. My mom was talking about how she was going to go get me a new air mattress, a better quality one, and that's when Lindsay goes, no, I have 2 twin mattresses inside of my garage that are just being stored. I'm not going to use them anymore. You can have those. And my mom goes, are you sure? Because I can set up a truck to go get one. And she said, yeah, I'm sure. She never said that she had to ask her dad for permission because they were hers.
We'll be back with more Judge Joe Brown in a moment.
Lindsay did give the mattresses to Ashley. I arranged for the truck and...
Excuse me, who he gave?
She did.
She doesn't have anything to give.
Then she shouldn't have told me that she would give them to me.
Closed captioning sponsored by...
We're back with Judge Joe Brown. The defendant in this case says the plaintiff's daughter was over at her house when she offered to give her 2 mattresses. She says she owes nothing since she was told they were just laying around the garage. Let's take a look.
You have title to the mattresses?
No, they're my dad's possession. He bought them.
Did you pay any money for them?
No, I did not. They were my dad's.
Anybody cede them to you?
No.
So, all right, where did you pay anything to her, by the way?
No, she said I could have them because they were not being used.
Well, how can she give you the property interest in items she did not have the property interest in to convey?
She told me they were hers. She never
So
said
what?
anything
She
about
didn't
her
have the
dad.
title. That's not the truth of the matter. If you had paid something and you were subject to fraud, in other words, all right, girl, I'll give you $150 for this. You might have been innocent purchaser of value.
my
You
mom
didn't.
asked her if
She's
she-
trying to give you a gift of something you didn't have. So you don't show me any detrimental reliance here. All you show me is you had an air mattress problem. And the air mattress problem was basically because there were 2 pooches running around in the house that needed some trimmed toenails, and they kept puncturing the air mattress.
Excuse me, Your Honor. Lindsay did give the mattresses to Ashley. I arranged for the truck and...
Excuse me, who he gave?
She did.
She doesn't have anything to give.
Then she shouldn't have told me that she would give them to me.
People don't, look, what is property?
She told us they were hers.
What is property? She said they were hers.
Everything in that garage being stored, she said, was hers from her old apartment.
Excuse me, the property owner is to your immediate right, young lady, and ma'am, next over from your immediate right.
Judge Joe Brown makes his ruling after this.
In a custody battle with your ex over the family pet? Call 877-JOE'S-LAW or visit JudgeJoeBrown.com.
There was no money that changed hands. There's no fraud that existed here that is operative because it didn't cost you anything other than the use of the items in question under the mistaken belief of yours and your mother that she had some property interest she could convey. You didn't get anything signed over to you, so nice whoop-de-doo, you had an opportunity to use them. Now either give them back or pay him the assigned value of $398, which is not unreasonable. Now, you have your choice. You get your award and your cost accordingly, either $398 or the return of the items. Now, in the discussion, life is life. Learn.
And this courtroom is now in recess. Well, the defendant in this case tried to conveniently stick with her friend's word that she could have those mattresses, but the fact is her friend had no right to give that property away. It was her dad's. He gets the value. We'll be right back. We're back. The defendant and her mom insisted they were given this property. It probably doesn't help out the friendship between the young ladies, but maybe those mattresses are worth it. The plaintiff wins.
For information on future cases or to contact this court, check out our website at judgejoebrown.com.